I'm sorry there was no sound. I didn't realize it. So thank you, Irish girl, for telling me. All right. So, couple things first. If you're new to my channel, welcome. Welcome to Perplexed. A channel that does not win the popular vote because I state the truth and my opinions that I have a pretty good track record. So, welcome everyone. If you don't like the popular opinions, then go ahead and hit that subscribe button. If you want to continue with me, go ahead and hit that subscribe button. You can also join Patreon at patreon.com/PerplexedQT. And I have multiple ways that you can donate. There's a glitch with the website. That's why it's not up yet. Otherwise it would be up, but there's a glitch with it that the company's trying to fix. So I can't go live until this one major issue is fixed, and that's the price change doesn't happen. And yeah, that's pretty important. Otherwise, people are going to get the wrong prices. So that's not up yet. But there, you can donate to me through Cash App. You can use PayPal, or you can just simply Super Chat. One thing I did get, and I'm very, very excited because I was waiting like a year, is now I have Super Thanks. And the Super Thanks is that if I'm offline, like you have a replay video, you can still send me a Super Chat. That's pretty awesome. I have been waiting for this for like a year. I thought I was never going to get approved, and finally I got approved. A judge says, any evidence other than your flapping gums? Huh? All right. So let's get into this. Hey, Kathy, let's get into this. Let me preface this by saying that I didn't watch it yet, so we're going to watch it together. I did get bits and pieces of it. I did hear bits and pieces of it. I was listening to multiple different people about it, and I got news for you. I'm pretty shocked at the stuff I heard because I disagree. And let me explain what I mean by that. And I'm going to go through it so you guys can actually see what I'm talking about and not just hear me say it. First, let me also say I lost my AC yesterday. We spent the entire night and day in like it was like 91 degrees in my house, and I was dying. So still had to work, but I was dying. And the dogs were dying and the kids were dying, and yeah, it was a rough night. But we made it through, and the AC got fixed this morning. So, all right, let's get into this. One of the things that, hey Texas, one of the things that I have a problem with this entire case is that they're talking about constitutional rights. One thing you guys need to know about me, I do not get emotionally attached to a case. Never have, never will. It's not my real life. I have absolutely no desire to get personally attached to any case that I cover. It's like, you know, every once in a while, will I get emotional over a case? Absolutely. Will I cry over a case? Absolutely. Will I think about a case? Absolutely. But I do not get personally invested. So with that said, understand that my view on this case is not that I think Brian Laundrie didn't do it, or that I think Brian Laundrie, you know, is a good person, or that I don't have 100% complete sympathy for the family, because I absolutely do. I have put myself in that position many of times. See, Texas girl, and I'm going to tell you why I disagree. Everyone keeps saying they agree with her, but Bertolino has nothing to do with this case at all whatsoever. He just doesn't. So I don't know what you're all agreeing with. Bertolino is not even mentioned in this trial. I mean, in this case. So people that want to bring up Bertolino, it makes no sense. It doesn't matter what Bertolino said. He's not part of the lawsuit. So they don't even mention him as being part of the lawsuit. There's nothing that gives Bertolino any ounce of anything in this lawsuit. I'm not wrong. And I'm going to explain why I'm not wrong. They have One of the things that I heard today, and I don't want to skip too far ahead, but one of the things that I heard today was one of the things that was, I guess, a point of contention or what they were discussing. They had stated that it's written in the letter, and this was JB, that lawyer guy, I forgot his name, and something else. But Lindsay, I'm not going to let you keep throwing me off track, but let me point out, the case wasn't in Florida. Bertolino is not a Florida attorney. He's a New York attorney. I'm not sure. No, not a troll. It's my own mod. I'm not sure if he's licensed in the state of Florida. I really don't know. But he's not a Florida attorney. He's a New York attorney. So Florida laws have nothing to do with any of it. Unless he's licensed in Florida, which I don't know if he is or he's not. But he was representing them from New York. So maybe I'm wrong there. Maybe he is licensed in Florida, but I don't know. The lawyer you know. Thank you. So the lawyer you know, I thought this was really interesting, the way it was said and how it was said. And the way it was said was JB had said hearsay is evidence. And the lawyer you know, very weird kind of way he said it. He's like, yes, it is. Yes, it is evidence per se. But at the end of the day, it's still hearsay. And to say that there's definitive evidence that they knew, that the Laundries knew, based on somebody told them that, that's not evidence. That's not proof. That doesn't put Bertolino in any kind of proof that he knew, that they knew, because they don't know. There's no proof. It seems to me what I understood from JB was that the Petitos feel this way, and the Petitos are looking at it this way because somebody told them that the Laundries knew. That's hearsay. That's not proof. Now, will somebody put them on the stand as it's proof? Of course. There's a lot of people that go on the stand as witness testimony, as, you know, that's their evidence, is they put people on the stand. But any judge has proven, and lawyers rip it apart because it's not proof. It's not definitive proof. So one person says that the Laundries knew, they can't prove it. And someone else saying it can't prove it. Now, if it was in the book, if it was in his notebook that stated specifically, like, I told my parents on August 28th that I killed Gabby Petito, that's proof. Now you have some definitive proof. But from what I understand, that's not what happened. And nobody even knows that Petitos have seen the book or the notebook or the contents of it. So, and from what I gather, and I could be wrong, but from what I gather from what I heard today, they still haven't stated, like, according to JB, it sounded like he was stating that they heard this from somebody and they're running with it. Could they have heard it from Cassie? It's possible. It's definitely possible, but it's still hearsay. Nobody can prove it in a court of law. Remember, this isn't a criminal trial. Criminal trials are a little different, but in a civil trial, that's not going to play with a judge. And I think the judge was, from what I gathered from other people that I saw today, the judge is kind of, he knew all the questions, all the answers to the questions he was asking. But he asked them anyway to see how the lawyers were going to play it. One of the lawyers, and I'm jumping way ahead, but one thing I did hear was one of the lawyers was going on about different references of, different cases, and he was going through case law, and he was so wrong on all of the case law. Like, yeah, the case law he was talking about was right, but they were against big companies. There's no statute that states that they can do what they're doing. What they did was, and I'm going to play the trial today, the pre-hearing. At the end of the day, what did the Laundries do? Morally, were they wrong? Absolutely. But they have a constitutional right to keep their mouth shut at all times. They have a constitutional right to not say anything. I know that the Laundries want answers. I would too. I understand that the Laundries want justice. I would too. I understand that the Laundries want whatever they can to, feel better about their daughter was murdered for absolutely no reason that they can come up with. I agree with that. But at the end of all of this, they didn't do anything wrong. They did not kill Gabby. They did not convince Brian to kill Gabby. They did not tell Brian to kill Gabby. They also lost a child. And I know that it's not favorable to like Brian Laundrie, and I'm not saying I do, but what I am saying is as a parent, they lost a child. And I hate to say it like this, but it's kind of like, okay, we're even. You guys lost child, we lost child. I'm sure Ted Bundy's mom cried when, he died. It's just weird. Like, this isn't about morals. You can't take someone to court for morals. But see, Rainey, that's where you're wrong. They did not pull shady shit. They kept their mouth shut. They did what our constitutional right tells you to do. Period. End of story. And if you take that away, if you remove that constitutional right and hold two people guilty for using their constitutional right, then what? Then what happens? Now what? How many other families are going to kill or going to sue the parents over what their child did? He was not a child. He was an adult. He is the only single person responsible for Gabby's death. Not his family, not his sister, not his parents. I agree, and I've said that before. And if you open up this door to, okay, well, morally, you don't have to, morally, you can get sued for keeping your constitutional rights. Well, then what? Then we just might as well toss out the Fifth Amendment. Because if you're the parents of a child, you're going to get sued, and now you're going to get screwed because now we're taking away a constitutional right. The Fifth doesn't apply to them, though, because no one was charged at that time. It doesn't matter. You can play the Fifth at any given time. If you think you're going to get charged, you can. You can. I could plead the Fifth at any given time. Whether I choose to, if, for example, Quinny, if I say Quinny robbed a bank, okay? And I know Quinny robbed a bank, and somebody was shot, do I have to say something? No. I could keep my mouth shut. I have every right to plead the Fifth, whether crime's been committed or not. Let's say nobody knew about it. If nobody knew, okay, if nobody knew that Quinny robbed a bank, I'm not going to say anything. If someone asks me about it, I'm just going to... But Lindsay, nothing is going to change my mind on this. Nothing. This is our constitutional rights. Plain and simple. You can't take that out. You can, just like gun laws, you can't take it out just because there's some crazy ass people out there. You don't take away gun laws because of crazy people. You don't take away your constitutional right. As shady as it may seem, it is their right. Their right. Well, the reason why I use that term, Texas girl, is because what I heard today was the guy kept saying what was outrageous. What was outrageous? So my title was, I think this lawsuit is outrageous. Laura is looking at the big picture, 100%. And again, I'm seeing a lot of emotionally invested people speaking right now. They're not thinking of the big picture. They're emotionally invested. Do not be emotionally invested. Legally, and again, I stress this, legally, the Laundries did nothing wrong. And the Petitos cannot prove their case. And their entire case is based on morals. It's not based on legalities. It's based on morals. And they can't prove what they're asking. Plain and simple. And I said this 6 months ago. Nothing has changed. Hold on. Okay. Hang on. All right, bear with me. All right, let's do it.
And good afternoon. I am electronically present in the courtroom today as I'm abiding by the court's quarantine protocols. We have technology in place to allow the court's work to continue without delay, which is the case involving the estates. So let's begin. The court's going to first call the case of Joseph Petito and Nicole Schmidt by the Laundries.
Wall and stare at that. Well, thank you, Your Honor, for your time this afternoon. I appreciate it. Your Honor, I won't spend any time going through the general standard on a motion to dismiss. I know Your Honor is well aware of that, so I'll just jump right in. Your Honor, our position is straightforward. A cause of action for intentional infliction of emotional distress was not intended to include liability for a defendant who does nothing, who has no contact with the plaintiff. All of our arguments regarding outrageousness, legally permissible conduct, causation, and the presence of the plaintiff all go back to that premise and show why there is no legal footing for this cause of action in this context. Conduct that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress. And there are no cases where such conduct was found to be intentional infliction of emotional distress. Rather, plaintiffs argue that the Laundries had an obligation, a duty to speak. The law imposes no such obligation.
Yo, you guys see Betty in the background? There's old Betty in that blue shirt, taking her notes, looking like a train wreck.
Obligation to speak. And the state and federal constitutions support that. In our society, under our laws, people are free not to speak. Your Honor, the elements of the cause of action alleged are a deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. I'll first address the outrageous conduct element, Your Honor. So the standard for determining whether or not
Now you guys are going to see where my outrageous comment came from. It's from the today.
conduct is outrageous is that the behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That is conduct that is atrocious and utterly intolerable in a civilized society. It is an objective standard, and the subjective response of the plaintiffs is not what controls. The issue of whether or not conduct is outrageous is a question of law and for the court to decide. And that standard is extremely high in Florida. It is not enough that the defendant acted with an intent which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Now, Your Honor, looking at the amended complaint in this case, paragraph 32.
Yeah, Texas, one of these lawyers, because I was only on, I was listening on my headset when I went to go get Buka his, dog pool. So I didn't know what lawyer was talking, but every other word, they used the word outrageous. So that's where my title came from. And you'll hear it. Like, all they say is outrageous over and over and over.
Provides a summary of what the plaintiffs alleged is the conduct that was outrageous. So they allege first, failing to advise the plaintiff.
Okay, but Boho Mom, I'm going to say this again, and then I'm not going to stop it. Otherwise, I'm going to stop every couple of minutes. But listen, I'm going to say this one last time. There is no proof that they knew. Just because the Petitos said it doesn't make it true. Just because the Petitos heard it does not make it true. And everyone is, in my opinion, emotionally invested because they're thinking that just because they said it, it's true. No, that doesn't make it true.
That Ms. Petito was deceased. Second, failing to disclose to the plaintiffs the location of Ms. Petito's body. Third, taking a family vacation with their son, Brian Laundrie, who they alleged had murdered Ms. Petito while the plaintiffs were looking for Ms. Petito. Fourth, blocking access to their cell phone and Facebook page to preclude the plaintiffs from contacting them and getting information regarding Ms. Petito. And finally, that the Laundrie's attorney, not the Laundries themselves, issued a statement to the press expressing hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family.
Notice she's on the Laundrie side. I just realized that Betty's on the Laundrie side. But everything that this man is saying, I'm sorry, they don't have to do the right thing. They are shitheads. They are wrong. They are assholes. But they didn't do anything that isn't our constitutional right, period.
Is there a distinction between the attorney doing it on behalf of the Laundries versus the Laundries?
Well, Your Honor, the attorney is obviously not a defendant in this case. And there are no allegations that within the complaint that the Laundries directed the attorney to make that statement, what information the attorney had with regard to making that statement. So I do believe that there is a distinction, Your Honor.
Isn't under Florida law, isn't the attorney the agent of the client?
I do agree with that, Your Honor.
Then why does it matter that the attorney and not the Laundries themselves made the statement?
Well, Your Honor, what we don't know, what is not alleged in the complaint, is whether their attorney was making that statement on behalf of the Laundries or whether he was making that statement in his personal capacity.
Well, on a motion to dismiss, how am I supposed to construe the well-pled allegations?
Your Honor, on a motion to dismiss, I would argue to the court that by not alleging in the complaint that the attorney was the agent of the plaintiff, or I'm sorry, of the defendants for purposes of making that statement, that the plaintiffs have not alleged sufficient conduct that would.
Okay, thank you, Judge. Thank you, Judge and attorney, because he just said exactly what I've been saying. He is saying that, the judge is not looking for evidence. Yeah, but John, he's still alive. The judge is not looking for evidence in order to see if you can move forward. The judge was asking him about this in order to dismiss it. That's why he was asking about it. The lawyer is 100% right. If this whole thing was based on Bertolino, then why isn't Bertolino listed on the claim? That's exactly what I've been saying. And they both just backed up exactly what I've been saying.
That would cause liability for the defendants for the statement by their attorney.
Well, assume for the sake of argument, the court concludes that there was sufficient allegations that the attorney is the agent for the Laundrie. So assume that to be true. Now we have a situation where the Laundries themselves are making a statement and not standing silent. So what does that do to your argument about staying silent?
Your Honor, I still don't think it necessarily makes a difference. I mean, I understand what the court's saying.
John, I'm going to answer this just once. That is a completely separate issue. They were involved. They bought the gun. They never pleaded the fifth, and their constitutional rights were not in question. It's a completely different case, completely different circumstances that you can't even compare.
That if we impute that statement to the defendants, that would not be complete silence by them. However, the defendants do have a constitutional right to have an attorney and to have that attorney speak. So again, Your Honor, in my view, the attorney was merely exercising the constitutional rights of both the attorney and of his clients.
Amen.
By making a statement.
Amen to that.
When you make an affirmative statement, that's the antithesis of staying silent, right?
I would agree with that, Your Honor, yes.
You may continue.
Thank you. Your Honor, the plaintiff's claim of outrageous conduct in this context is novel. The plaintiffs have cited no cases where a person's silence, except with regard to what Your Honor just raised with regard to their attorney's statement, was considered outrageous, regardless of the circumstances. And they certainly haven't cited any cases where a statement by a person's attorney has been considered outrageous. All of the cases they've cited involve some action by the defendant. Accepting the allegations of the amended complaint as true and allowing the case to proceed further would require any person and their family to speak about an alleged crime or other tragic event of which they may or may not possess knowledge, and that is simply not something that our legal system requires. For example, if a family member came to me and told me that they did something terrible, the plaintiffs want the law to impose an obligation on me to then report what that family member told me, and that just isn't the law. I'm sorry, go ahead.
Let me make sure I understand what you're saying. Are you saying that they came to you in your capacity as a lawyer or as just a normal person?
Just a normal person, Your Honor, just a family member.
Okay, well, does Florida recognize a privilege, a parent-child privilege?
Your Honor, I'm not arguing privilege. This could be somebody who is not a parent, a child, a wife, a husband, just anybody. My argument is not that there was a privilege between Brian Laundrie and his parents. My argument is that even if Brian Laundrie conveyed information to his parents, that they don't have a requirement then to speak with regard to that information.
Exactly.
They don't have to share.
Okay, well, let's go down that road for a moment, because this is where I'm having some difficulty. I fully understand and get the constitutional right to remain silent. That being said, we're on a motion to dismiss on a complaint where I have to assume the facts are true. And you're
Okay, so let me just explain to you, Lindsay and Texas Girl, you guys are confusing what the judge is saying as reality. And what I mean by that is he's not using this to try the case. He's not stating these facts as the Laundries are wrong. He's stating this as this is a motion to dismiss. He knows all the answers to the questions he's given the lawyer, but he's looking to see how he can get answers from the lawyer on this motion to dismiss. From what I'm getting from feedback, from what I saw feedback, some people are misconstruing what the judge is saying as if this was the lawsuit. He's basing this on just a motion to dismiss. He's gonna say things that are different.
You're trying to get me to say that the complaint itself demonstrates the existence of right to remain silent. And I'm trying to understand how that is, or is that more of an affirmative defense that should be fleshed out in the pleadings?
Your Honor, I don't agree that it's an affirmative defense that needs to be fleshed out. I believe the court can, obviously the complaint alleges that the defendants were residents of the state of Florida, so the Constitution of Florida and the Constitution of the United States apply to them. And if you look at the complaint, Your Honor, even though it doesn't allege a formal criminal investigation, it doesn't use those magic words, so to speak.
But if you guys know what's going on, then you would have prefaced that when you made your statements, because he's only using those statements on this motion to dismiss for answers he already knows. But he can't just dismiss it unless he gets the lawyer, their attorney, to get more specific. He's trying to get the right answers to dismiss it.
It does allege that Brian Laundrie murdered Ms. Petito. It alleges that Brian Laundrie engaged in conduct to try to cover that up by sending text messages and things like that. It alleges that the defendants, his parents, the Laundries, were trying to help him escape the country. It alleges that the Laundrie family hired an attorney, and then once they hired the attorney, at that point, all the contact with the plaintiff stopped. And the only statement we have is that one statement by their attorney that the court referenced. So under those circumstances, as alleged in the complaint, Your Honor, that's enough for the court to say somebody in that situation could invoke their Fifth Amendment privilege. That's not something that the court would need to find additional facts. The court does not need to look outside the four corners of the complaint. There are sufficient allegations within the complaint that would trigger somebody in that situation exercising their Fifth Amendment privilege. Your Honor, would you prefer for me to continue with the outrageous element or move on to the legally permissible element, since that seems to be...
Whichever way you want to go.
Okay, thank you, Your Honor.
I'm not shy in asking questions.
I understand. Your Honor, the plaintiff's cause of action could also extend to somebody who, may not be in the situation where they were told something, but maybe they witnessed something, or maybe they came upon some evidence, or somehow they had some information that might be relevant to some tragic event. The plaintiff's cause of action would impose an obligation on people like that to contact the families who may be involved in that situation and disclose what they knew, or they would fear being sued. The slippery slope of allowing this cause of action to proceed would really require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or potentially be exposed to liability. Now, the underlying crime...
But again, I go back to, there's an allegation that the Laundries made an affirmative statement and put out into the public various statements. So am I not supposed to consider that conduct because that's a voluntary act by the Laundries?
I understand, Your Honor, and I assume you're referring to the one statement by the attorney alleged in the complaint. Assuming for the sake of argument that that is an affirmative statement by the Laundries, Your Honor, you can definitely consider that. But again, in the context of the overall case, is that statement alone sufficient to meet the standard for outrageousness? If, let's say, for example, I had some knowledge about a crime that somebody committed, and I made a public statement about some aspect of that case, but I didn't share everything that I knew, or I hedged my bet, so to speak. Would I then be subject to liability because I shared something, but I didn't share other things? That's really the question, Your Honor. What are we going to require of people in a situation like this? Are we going to require them to say everything that they know, or are they going to be allowed to speak or not speak at all? That's really the question before Your Honor. And Your Honor, I think it's important to keep in mind the standard that we're talking about here, that the conduct has to be atrocious and utterly intolerable in a civilized society. People who are faced with difficult challenges have to make difficult choices. And our society, which I would propose is civilized, recognizes at its core that things like remaining silent or speaking through an attorney are foundational rights.
Absolutely.
And those are choices that our society considers entirely tolerable. And in fact, they're codified in our founding documents. So, Your Honor, even considering the statement by the attorney, I would submit to Your Honor that that's not atrocious, it's not intolerable in a civilized society for their attorney to make a statement for them.
I agree.
Your Honor, another thing I'd like to address that the plaintiffs raised in their response is that that the Laundries were somehow in an unequal position to the plaintiffs, and that made their conduct particularly outrageous. Your Honor, I don't think that the standard for unequal positions is really what the plaintiffs would qualify that under this circumstance. Your Honor, in Dependable Life Insurance Company versus Harris, which is a 5th DCA case from 1987, it's cited in our papers. Your Honor, in that case, and what the plaintiffs rely upon is Restatement of Tort, Section 46, subsection E, which states this unequal position argument. And what the restatement says is, the extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with an...
Texas girl, I should be keeping track of how many times they say the word outrageous.
Other, which gives him actual or apparent authority over the other or the power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the annoyances that are not extreme, even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. So, Your Honor, in Harris, what the court recognized there is that the result of this unequal position must be something that is akin to extortion, meaning that somebody threatens another person based upon their position to cause some harm. Like, I'm gonna cause you to lose your job. I'm gonna cause you to be arrested. I'm gonna hurt your family, something like that. That's really what it's about. It's about somebody who has some authority to affect the person's life. It's not a situation where somebody might have information that another person doesn't have and they simply don't share it. That's not really what the Harris case or what the restatement are talking about when they say unequal positions. Now, Your Honor, moving on to the assertion of illegal rights. The standard with regard to that element is that the conduct, although it would otherwise be extreme and outrageous, may be privileged under the circumstances. And the actor is never liable, for example, where he has done no more than insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. Now, we have several rights at play here, Your Honor. You brought up one earlier, the Fifth Amendment right to remain silent. That is certainly one of them. There's also the First Amendment right of freedom of thought, which would include both the right to speak freely and the right to not speak at all. And that was cited in Woolley versus Maynard, a Supreme Court case from 1977. Again, it's in our papers.
Aren't we responsible for the words that we say when we say them?
I would agree with that, Your Honor, certainly. Certainly, if you say words...
Johnny Depp just got found civilly liable for defamation by what his attorney said, right?
Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially be, lead to something like defamation. I agree with you on that. I think really what we're talking about here, though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it's not outrageous.
My understanding of the statement, and correct me if I'm wrong, is the Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that it is true, but I have to accept it as true. That the Laundries knew where the Gabby's body was, and they put out a statement in the middle of the search, hoping about the success of that search, and then not either directing them or either staying silent. I mean, that's kind of my understanding of what is being alleged. Is that correct, or am I misunderstanding?
No, I believe that's my understanding as well, Your Honor, that the attorney made the statement while the search was ongoing.
And knowing exactly where the Gabby's body was.
Well, Your Honor, again, that's the rub, is the plaintiffs haven't alleged anything in the complaint as to what the attorney's knowledge was when he made that statement, that he had that information. That's a totally different thing. They've alleged that the parents, the defendants, had that information, but they don't allege that information was ever shared with the attorney, or that the attorney had that information when he made that statement. That's kind of the issue, is they haven't really made any allegations about the attorney and what he may or may not have known. It's really all about what the parents knew. And they don't make any allegations about what the parents communicated to the attorney. So really the attorney's statement, again, if just looking at it within the four corners of the complaint, there really isn't enough there to say that whether or not when the attorney made that statement, what his knowledge was about any of the facts of the case, frankly.
Now, let me say this. What I think I think the judge is like crossing every T and dotting every I to make sure that this can't go on appeal. That because it is a motion to dismiss, he is covering every possible question that could come up on appeal. And I don't know, I get the feeling at this moment that he agrees this lawsuit should be thrown out. Just my opinion.
And I would also submit to you, Your Honor, that statement's fairly benign. I mean, I understand in the context that they've alleged it could be construed as trying to divert attention or something like that. But again, it's a fairly benign statement. I mean, he's really just expressing that he hopes that she returns. And again, they haven't alleged what information he had when he made that statement.
Isn't the context really what's important here? And that's what the second DCA said in that insurance case where the adjuster denied coverage and did so knowing that the person didn't have long to live and just wanted to outlive the person. And the second, which is binding on me, found that to be outrageous conduct.
That is true, though, Your Honor. In that case, the second DCA said that the actions of the insurance company in simply denying the claim, even though they had been ordered by a judge of compensation claims to pay the claim, that in and of itself would not have been outrageous. But what made it outrageous was that there was some sort of internal decision made that they're just not going to pay it for a certain period of time in the hopes that the plaintiff would die. I agree with you that made that particular case rise to the level of outrageousness. Your Honor, frankly, the statement by the attorney in this case doesn't come even close to that level of outrageousness. I mean, you're talking about withholding medical care in the hopes that somebody dies so you don't have to pay for it. I mean, I don't think any of us sitting here would not find that to be outrageous. We're talking about a statement by an attorney.
Chat with you and somehow death loses its sting.
I wish you could just shut your big yapper!
You jackass!
Boilerplate and generic, just expressing that he hopes that the search is
jackass.
successful and whatnot. I don't really equate those two. I mean, I do agree with your point, Your Honor,
wish
that
you could
the
just
context
shut
is
your
important. We do have to consider the context as alleged in the complaint in this situation. But I would just submit to Your Honor that even considering that context within the complaint, the attorney's statement is not outrageous.
You have about 5 minutes left in your argument.
Okay, thank you, Your Honor. So I'll move forward, Your Honor. I know we filed a motion and Your Honor has read it, so I'm not going to try to belabor too many points here. But with regard to the assertion of legal rights, really, the plaintiffs recognize that the Laundries have constitutional rights, and that the conduct that they have alleged within the complaint is really an exercise of those rights. So what they argue in response is that the court on a motion to dismiss shouldn't consider certain things. Number one, because they allege that within the complaint they haven't alleged state action. Number two, that they haven't alleged any constitutional rights within the complaint, and so the court shouldn't consider them. And then fourth, that the constitutional rights are affirmative defenses. Your Honor, with regard to the state action argument, as an initial matter, just because the government isn't trying to compel someone to do something doesn't mean constitutional rights don't go away. If you don't protect your own constitutional rights, even when the government's not trying to do something to you, then you would likely
Okay, that chick in the black has an attitude that should not be in a courtroom. Like, get over yourself, lady.
waive them. If the defendants in this case had made a bunch of statements, even if those statements weren't to law enforcement, those statements could absolutely be used against them. So, in that sense, Your Honor, those rights exist, irregardless of whether the state is involved. Your Honor, also, as a second point, there is state action involved here. And one of the cases we cited to Your Honor in our motion sort of sums it up. It's Gerber versus Longboat Harbor, North Condo. It's a Middle District of Florida case from 1991. And that court said, defendant's motion to dismiss is predicated upon his assertion that, since it is...
Just so you guys know, he's talking a little fast because I have it sped up. I don't want anyone to mistake that. Yeah, I have it sped up. You know what? Hold on. Texas girl, I forgot your insult.
Well, honey, your mother sure dresses you funny.
It's bullshit. Everything with you is bullshit.
Ball sniffer.
Not a governmental entity and does not assume substantially all of the functions of a governmental entity, the provisions of the First Amendment as incorporated in the 14th Amendment simply do not apply. This court cannot agree with defendant's contention, and by applying the principles enumerated in Shelley versus Kramer, which is a Supreme Court case that sort of set forth that the third branch of government, the judicial branch, is also state action. This court found and continues to find that judicial enforcement of private agreements contained in a declaration of condominium constitutes state action and brings the heretofore private conduct within the scope of the 14th Amendment, through which the...
Thank you, Whistle Down.
Laugh a while you can, monkey boy.
Why don't you put your thumb up your butt?
You rotten, no good for nothing, keyboard humping, screen
Preview.
cyber hoe.
First Amendment guarantee of free speech is made applicable to the states. Now, obviously, we're not dealing with a contract here or a condo association or anything like that, but the point is the same, that when a party tries to use the courts to enforce something, then there is state action. And in this case, Your Honor, the plaintiffs want the court to enter a judgment against the defendants. They presumably will want the court to enforce that judgment, and they want to use the court's authority to compel the defendants to participate in the discovery process, all of which implicates their First Amendment, Fifth Amendment, all of their rights, Sixth Amendment right to counsel. So, Your Honor, in that regard, there is state action. I addressed the criminal investigation earlier, so I won't go through that again. Your Honor, with regard to the four corners of the complaint argument, like I said before, the Laundries are residents of Florida. It's alleged in the complaint. As such, the Constitution fully applies to them, and the court can consider those rights. The plaintiffs are essentially asking the court to force the defendants to go through discovery, pretrial proceedings, summary judgment, just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources and the resources of the parties. Your Honor, with regard to the affirmative defense, nobody cited any cases where the legally permissible element is labeled an affirmative defense.
Oh, you guys didn't hear me. All right. So Gabby's parents, mom and dad, Joseph, and I forgot her mom's, Nicole, I think, they're the ones sitting at the front table next to the lawyer. The bald guy behind him, that is Gabby's stepdad. And the blonde to the right of him with the gray tank top like on, that's her stepmom.
Defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. Rather the legally permissible element is really intertwined with the outrageous elements. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action, the court explained how it applied in that case. And it said the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Rather, the insurance company, according to the terms of the policy, had the right to demand proof of ineligibility from Medicare. And then it goes on and it says, Metropolitan did no more than assert legal rights in a legally permissible way. As such, Metropolitan's actions are privileged under the circumstances. So, Your Honor, it's not really a defense. It's really part of the outrageousness calculus, that the conduct isn't legally outrageous if there is a privilege or a legal right that's being asserted. And Your Honor, we cite some additional cases in our reply that I'll rely upon in that regard. Your Honor also said that even if this is an affirmative defense, which I don't think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime was committed. They allege an attorney was hired. So it's not a situation where the court can't.
Yes, and the girl in the blue behind him to the right is Betty Bullhorn Butthead.
Consider the defendant's constitutional rights. And in fact, in the case Huzzar versus Gross, which we cited in our papers, it's the first DCA case from 1985. It's a defamation case. And in that case, the court was considering a First Amendment privilege on a motion to dismiss and held that trial courts, upon motions to dismiss, routinely make decisions as to whether
Identified what you contend is one crime, which is to actively assist Brian evade capture, essentially. Assuming, of course, that and not this is not within the four corners. I mean, we know outside of the four corners, but not in the four corners. Is there an allegation that there was an arrest warrant out for him? But assume, for the sake of argument, that is sufficient for purposes of us to find that there was some sort of active crime, if you will. Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime. You just have to believe that you may be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Your Honor, I mean, I don't disagree with you on that point. What I'm saying, though, is there doesn't have to be a formal investigation. If I left this courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like, I can assert my silence for as long as I feel like I need to protect myself.
That's exactly what I said before.
Because, you know, the case law I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question. So, for instance, if the question is, what is your name? You might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a better standard as to whether or not?
All right, I have a question, guys. Can you guys just tell me how such an intelligent judge doesn't shave this little doopy thing on his head? Can someone explain this to me? Shave this little doopy thing. Just saying.
Your Fifth Amendment argument actually is applicable?
I don't think so, Your Honor. I mean, certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, you know, potentially were trying to assist Brian Laundrie in leaving the country, which could be an obstruction, could be something else. There could be, you know, again, we're not leaving the complaint when we talk about that. And so in that regard, you know, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation if there is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona, the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will.
Come on in, you psycho.
You schmuck! Why would I want a picture of a pitiful pencil-neck geek?
If you ask me, the guy's a few tacos short of a combination plate.
So it's the defendant's exercise. It's not something where you know, the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all.
Wait, you missed your insults.
If you ask me, the guy's a few tacos short of a combination plate.
Preview.
We got a learning disability here.
Well, what the hell is supposed to do, you moron?
Does that compute? Or do I have to draw you a schematic?
Preview.
Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part as an individual's substantive right, a right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. So again, Your Honor, it's not, in Miranda versus Arizona, the court wasn't parsing what questions a defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life. They can maintain that privacy for as long as they're able. Now, of course, like there are certain situations if defendant is subpoenaed to testify, perhaps like, you know, certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is. This is, you know, again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything. That's just not the way our society works. It's not the way, you know, it's not how the Constitution works. People are protected until they're not. And so that, in my opinion, Your Honor, I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they can withhold all information until it's compelled of them. That's, you know, or they're provided immunity by the government or whatever the circumstance might be.
Well, let's put a pin in that right now so I can hear from your opponent.
Yes, Your Honor. And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
May it please the court. Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint, and I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Bennett?
Zero.
That's a fair question, Your Honor, and I've struggled with the answer to that particular question, and I guess maybe by answering this I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped the situation tremendously.
They could have, but they're not obligated to do so. And again, it goes back to your constitutional rights. If we sue them, if they win, based on what morally they could have done, well, now you open this up to a whole new level of we no longer can plead the fifth. Because they can't prove what they're saying. They don't know if they did it. Conduct, that's fine, but this isn't about conduct. They're not obligated to say anything. You can't sue people based on morality. You just can't.
Tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was.
No, they
knew
didn't.
that the Petito family was desperately searching for information. But they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was. Not only did she not...
Let's get back, though, to legal duty. I hear what you're saying, that these facts might sound bad, but, you know, we're not talking about social mores here. We're talking about legal duty.
Thank you.
Let's
thank you, Your Honor.
on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were, their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home.
That's an excellent point, JT, and JT was right. JT, you are 100% correct. This lawyer is putting out statements that if he cannot prove, now they have a defamation case. 100%. I mean, this lawyer is putting some bold-ass statements out there that he won't be able to back up unless it's based on somebody else's statement.
They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. Admittedly, it's difficult to say what it is, and that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented,
But they never even named the lawyer in this lawsuit. Bertolino's name is nowhere on this lawsuit. It's like they were trying to find some legalese, some little thing after they filed the lawsuit. He's not even mentioned in it. That makes their entire point moot.
He was making that statement on behalf of the Laundries because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative duty.
Are you guys all taking a shot every time they use the word outrageous on both sides? Now you get it, Texas girl? Is it clear as day?
To speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion where the court found that there was outrageous conduct. And I don't see how any of these cases.
Okay, now this part I heard, and I absolutely argue every single one he presents, and I'm going to explain why.
Are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done.
Okay, right there, it's totally different. You're talking about an x-ray. You're talking about suing a hospital. It is not even comparable.
She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of the teacher wrote, published, and circulated a newsletter in which they...
Again, he's talking about a business.
Had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor. Contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because 2 of the debtor's children have been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous.
These have nothing to do with this case. They're not even close to being the same range. This is what I think is outrageous. His case law sucks.
Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant.
Bold and brazen, that's my whole point. That's exactly what I'm saying. These case laws that he's using is not even comparable to this case. They're not even close.
Transplant, even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these 2 last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a video camera and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers.
Okay, they never shared them with other cops. Cops didn't. It has nothing to do with this case. Nothing. This is word salad.
From surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said.
But what's crazy, Adrian, is they're both doing it. Like, both of them use that fucking word more than I've ever heard.
As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable.
The judge definitely does not know more than the lawyers. And I'm sorry, but I do not believe that they have evidence to prove their claim. Because I believe if they did, this is my own personal feeling. If they did, if they had this proof, they could be charged criminally. And they can't be charged criminally. So that tells me they don't have this definitive proof. And it's all hearsay.
One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous. And at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more.
Again, he's using totally different case law. He needs case law that goes one against the other, not people suing hospitals. That's outrageous.
Instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses.
Now, let me answer that, Hook. I don't know the legal answer for that. I can only go with, that's what I'm saying, VZ. I can only go with my opinion and what I know. So, I think, and again, it's just what I think that if they had this definitive proof, then they could go after them criminally, whether Brian was ever charged or not. If they had this definitive proof, and it was like legal definitive proof, they would be able to sue them. I mean, they would be able to charge them criminally. It doesn't matter, Lindsay. He's talking about police. He's talking about a cop that working the case. The Laundries aren't police officers. You can't say that, you can't compare the cops taking video and laughing about it is the same as people who lost their child from suicide due to pressure or whatever. It's just not the same thing. It's just not comparable.
Nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, a complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said.
I got news for you, Verika. I don't believe that. I think they're playing into people because I don't believe that. And I guarantee, I'll bet $100 that I'm right. This will never go to trial. There is no big bomb that they're sitting on. The only big bomb they're sitting on is somebody told them this. That's what the impression I got today. I could be wrong, but that was the impression I got today, that it's all hearsay. Somebody told them that they knew about it, and that's why this thing was filed. There's no definitive proof anywhere.
We believe that the appellee's conduct in making false statements, and isn't that what Mr. Bertolino did on behalf of the Laundries here? We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior.
And that, Pearl, I totally agree with. If they were suing Brian Laundrie's estate, I'm all with them. 100%. Totally with them. But they're not. They're charging his parents, and I think it's ridiculous. This will never go to trial.
Which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible...
No, I do believe that, Texas girl. I absolutely do believe this. And I absolutely believe that this will never go to trial. I'll bet $100 to anyone that wants to take me up on it that this will not go to trial. This is going to get thrown out.
...to emotional distress. And the Laundries knew that because this family publicly said they were distressed trying to find their daughter. The actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of Tort Section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we too, we know she was our son's fiance, and we hope that you find that body too, or you find her and the family is reunited, excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Burke...
It's callous, it's shameful, and it's wrong, and it's morally defunct. And who does that? But at the end of the day, they didn't do anything illegal, and they didn't do anything legally wrong. This is not a court issue. This is a moral issue. You don't sue somebody over morals. Sorry, not sorry. Hey, Grandma Rose.
is not a defendant in this action is because he's not a citizen of the state of Florida. I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interest of the plaintiff because they could have told them where her body was located, and they chose not to do so.
Lindsay, he showed two major differences. One of them was police, and one of them was a hospital. You're talking big business. You're talking totally different circumstances. That's not two innocent families. Totally different.
Your Honor, I don't think there's any question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients to the extent that they would suggest and have suggested, well, they were already distressed anyway. So all we did was increase the
Thank you, Daffodil, and I 100% agree with you.
Do you understand any English, toad-faced?
I ain't sending you shit.
Preview.
Your head is as empty as a eunuch's underpants.
Preview.
You're either incredibly smart or incredibly
Preview.
their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the...
So now here's another question. As a parent, do you think the emotional distress would have been less if they found out that Brian killed their daughter? Is the emotional stress that they didn't tell them, or the emotional stress that their daughter was brutally murdered for no apparent reason? To me, it would have been the same. They still would have had emotional distress whether they said something or not. They found the body pretty quickly.
Defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive. I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime.
Hold up, hold up, hold up, hold up. He is correct in that. But they were under police surveillance. So if you're under police surveillance, can you plead the fifth? Can you use it if your house, your moves, your every moves are under police surveillance 24/7? That has to give you some leeway for pleading the fifth.
So first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly, you can't look at the complaint and determine was there an investigation into them and what were the crimes. So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct. More importantly, the First Amendment is...
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were...
Okay, but whistle down. I think people are getting too hung up on the first or the fifth. At the end of the day, they don't have to say anything. They were not under a legal obligation. They were not, morally yes, but legally no. So forget the first, forget the fifth. They don't have to say shit. Plain and simple. You don't need a label for it. They don't have to say anything. They're not criminally charged. They're not under any kind of warrant to say so. They don't have to say anything. I don't have to say anything if I know my son committed murder. I don't have to say anything. I'm sorry that people may not like it. but I don't have to fucking hear it. Say it.
Making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question is, now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime if they are making efforts to try to remove him from the country? He's not been charged with anything. He's not a fugitive.
If he's not a fugitive, okay, this is where I'm not understanding this. If he's not a fugitive, then they didn't do anything wrong by trying to get him out of the country. Do you see what I'm saying? If they keep saying he wasn't a fugitive, then they did nothing wrong wanting to send their son to Guam. They didn't do anything wrong if he's not on, so they're like kind of mooting their own point. I don't get, you can't play both sides. If he's not under any obligation, then they have every right to send their son wherever the fuck he wants to go.
There's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis. If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant.
They don't, Janice. They're just throwing this out there.
Statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint? No, it's not.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support, that they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concerned for preventing government from compelling individuals to mouth support for views they find objectionable or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at...
Okay, in all fairness, we don't know what Bertolino knew, so they're saying we don't know exactly when they knew. I'm sorry, I go back to what I said. This whole thing is asinine. And it's outrageous.
Thank you, Your Honor. Are the Laundrie suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that she's no longer alive? Do they believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where's the duty, and certainly there's no...
Oh, Frankie, I'm well aware of what they're trying to do, but they can't prove it.
Legal prohibition on calling a lawyer.
Judge, I'm not going there. I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor, I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a third DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive because it involved the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now,
now this guy is stating case law that matters. Like, thank you. At least there's one here that's actually stating case law that matters. Listen to what he's reading.
The plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress. And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just...
No, he is way more on point. Why? Because he's actually using case law that is comparable. The other one is not using any case law that is even close to being comparable. Totally different.
Submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor. No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so...
That's fine. While Mr. Luca is cleaning up, is there anybody that's going to be here in the second case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115 SC?
Your Honor, Patrick Riley on behalf of Nicole Schmidt as personal representative of the estate of Gabrielle Petito.
Okay. And has anyone appeared for the respondent?
No one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action. It's been more than 20 days since I served the complaint on Mr. Spivey, but out of an abundance of caution, I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to and that a default will be entered.
Okay. Well, Deputy Velez, if you could sound the halls for Barry Spivey as curator.
They're going to play golf later.
Okay, thank you. The court deputy advises.
There's
no
Betty
response
running
to
out
sounding the
after
halls.
him.
Okay, well, let's, what's your intentions then in this case, Mr. Riley?
Your Honor, I've never had a situation where it's quite like this. So I don't think I'm obligated to give the Laundries 20 days from the time they were appointed as administrators ad litem to defend the action. But to avoid any future issues, I'm going to give them 20 days, and then I'm going to file for a clerk's default.
Okay. And you requested a jury trial in your complaint, I believe?
I did.
Okay, so we'll then have to have a jury trial on the issue.
Yes, Your Honor, we would be prepared to proceed to trial on that matter quickly.
Okay, well, I mean, it's a little premature relative to no default, but are you looking towards November, December, or what was your
I
trial?
Without my trial calendar here, Your Honor, I'm not certain, but probably more likely sometime in early 2023.
Okay. Well, I mean, hopefully for case management in the future, you can bring your trial calendar.
I apologize.
Okay. Well, we'll wait and see.
Willow, that's what I said at the very beginning. That is the first thing I said, that if you do this, you're opening up a door that you'll never be able to close, and then everybody's going to start suing, and you can't do it. This case will get thrown out. It will get dismissed.
See whether you obtain a default or if someone appears. Obviously, if someone appears.
Now, let me state this. Them suing Brian's estate, that can win, and that will definitely go to court. I see going to court. They have absolutely have a right to sue Brian's estate and take whatever they can, 100%.
I want you all to go ahead and do the case management order and get deadlines set.
Badger, that would be great, but I don't believe that happened.
And so that we'll get the case rolling. If you end up having a default, then we can set a trial. I don't think necessary.
Here's my opinion, and it's just my opinion. Badger, based on that, if that was true, I don't think Brian's parents would fight it. I don't believe that they would fight anything that was that obvious and that easy. Like, okay, well, Brian wrote it, so how are we going to fight this? I don't believe they'd be fighting this. And I don't believe they would pay for an attorneys to fight this, because as far as I understand, they're only getting sued for like 30 grand. An attorney could cost that much. I mean, 30 grand could be eaten up instantly. So that's why I know that did not happen.
So we need another case management. You know, we've got a November 14th, December 12th, then we'll, in the new year.
I can look at my calendar now.
Yeah. Well, I mean, I can't set a trial right this second because there's no default.
True. Okay.
But the reality is, because you requested a jury trial, we're going to have to impanel a jury on it, assuming that you're going to proceed with the case. I mean, obviously, if you decide not to proceed with the case, then we don't need to have it. But we'll call a jury, and we'll go from there.
Very well.
It's just, I'm trying to figure out, with all the other trials going on here and which judges are going to be here when, just need to start planning these things out.
I hope that doesn't mean what I think it means, but for next year.
Oh, I have no idea which judge is going to be here in 2023. That's the chief judge's prerogative.
Understood.
Yeah. So I will not reset a case management if Mr. Spivey or an administrator shows up. I'd ask that you go ahead and do a case management order and send it in, a report. If it is a default, send my judicial assistant word that the default has been entered and a couple of dates on our trial calendar where you're looking for the trial to be had, and then we'll go from there. Assuming that there is a default, how many days of trial are you anticipating?
1 to 2 at the most. The witness list will be short.
I suspect jury selection will take us a little bit of time.
Well, yeah, that's why I was saying 1 to 2, because I think I could try the case in a day.
Okay. Anything else in the second case, Mr. Riley,
No, Your Honor, thank you.
No? Okay. With that, we're going to be adjourned for the afternoon. Thank you all very much.
And Lindsay? No, Badger. Allegedly, it's somebody told them. That's what I was told. It's the principle of the matter, exactly. But the principle of the matter is they can't do anything. I'm telling you, this will get thrown out. The first one. I don't know about the second one. I don't know really much about the second one, but I do know the first one will get thrown out. They have no case. And Lindsay, you want me to see both sides, but when I take a stand on something, I haven't been wrong. If someone could show me where I've been wrong when I really take a stand, I'm all for it. Go for it. But you're not going to find it. Because when I take a stand, I'm right. FBI told him because, no, it's not in the notebook, Badger. That's already been thrown out. Texas girl, that's outrageous. But I'm serious, Lindsay. Show me where I've been wrong when I really take a stand on something. You won't. Because I haven't been wrong. Well, that's what I said, Daffodil, too. Okay, Badger. You claim you're right. You go with that. You go for that. But you're wrong. Would have bugged that house. Absolutely. 0 lawyers are giving this suit a snowball chance. Exactly. It's not. And I said that 6 months ago. So I'm not even going on, like what lawyers said today. I said this 6 months ago. I said this case is going to get dismissed. It's not going anywhere. And I still stand by that. And I stand by that even more now. Because again, you just can't do what they're trying to do. If it's not, like I was saying before, if it's not a Fifth Amendment right, okay, it's not a Fifth Amendment right, but okay, Badger. Okay, so it's not a Fifth Amendment right, but guess what? Guess what? Then the Laundries are not responsible if they want to send their son out of state. Like, you can't have it both ways. Welcome, Daffodil. Up, you get more insults. Hold on.
If elected mayor, my first act will be to kill all of you.
Thank you for the glib, self-serving solution to my fragile emotional...
And here come the freaks now.
Okay. I mean, that judge was totally grilling that. No, he did that on both sides, Badger. Laura will put you in jail and don't ask questions. No, absolutely not. But there's certain things that it is what it is. But like I said, I do listen to both sides. But there's certain things that there's not another side to it. Hey, Margie, there's just not another side to this. The Laundries are horrible people. The Laundries are disgusting people. The Laundries are pieces of shit for what they did. But that doesn't make them morally responsible for somebody else. It just doesn't. And again, if you start that, then you open up a can of worms that should not be closed. That'll never get closed. And you take away somebody's rights. You got wrong, I'll email. Okay, Lindsay, you email it to me. And not on opinion. I'm saying that when I say something like, this is the way it is, or this is why it is, show me where I've been wrong. That's what I'm saying. That's all. Yeah, a list. Although Lindsay did give me a good book to get an audible, and I've been listening to it. And I have to make some candles tonight. I'm going to listen to it. But while we were live, I did get an email from the company that is fixing my website, and they said we're checking it out and we'll update you today, because they're on the other side of the world. They write me at like 4 a.m. I was like, you must be on the other side of the world, because it's 4 o'clock in the morning here. Oh. 10 pages. Been Texas girl. Now you see why I used the word in my title? I mean, I didn't even listen to the whole thing, and all I kept hearing today was outrageous, 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 outrageous. I'll wait for those 10 pages, Lindsay. Sorry, I'm going to get off, though. I have candles to make. You can't inflict by inaction. They thought of that when they made laws. Good point. No, it's all about souls and what happens when you die. It's like a case study. And so far it's pretty good. Some of them I don't totally believe, but one of them like coincided with the exact dream I had like 2 days prior. So that was kind of weird. So I've been listening to it while I've been making candles. Oh, lawyers absolutely know it's a difficult case. But honestly, I think both lawyers did a fantastic job. I've been waiting for the moment to bring up this list. I'll wait, Lindsay. You know my number. So, all right. I gotta go. I gotta make candles. But let me tell you, that was the one good thing about having no heat last night. I mean, no AC. Now, one thing about candles, they form, I guess the right word I'm looking for, much better in heat and hotter weather than in colder weather. And these candles came out perfect. Like, it was so hot that it came out fucking perfect. So, hey, Brian, the Laundrie suck. Absolutely. Absolutely they suck. But they didn't do anything legally wrong. And no, this book is called Journey of Souls. It's actually really good. I'm not one to sit down and read, so Audible works for me. Even though the guy's kind of annoying. Lindsay's right. The guy's inflections and stuff are kind of annoying. What case study? Do you have a link? Yeah, hold on. I can give you the Audible link. It's called Journey of Souls. By some doctor. But it's a big case study about what happens when you die. And it all comes back to his dream I had the other day. And this one case study, like, literally explained almost my entire dream. But like I said, some of them I don't believe. Some of them I think are, I don't know. I'm just not buying all of them. So, all right. Before I get too tired, since I am actually going to sleep at a normal hour tonight. I promise. So I'm going to go make some candles. You say in a passage that the only person in the world that is not required to speak if they know somebody committed a crime is a priest. That is correct. That they're not obligated. And legally, they're not. The Laundries aren't legally obligated to say anything. They're trying to sue them on moral. You're welcome, Angela. They're really trying to sue them for morally. And you can sue people for moral issues, but I don't think in this one. I know it's peaceful going there. I'm telling you, it was weird. I had this dream, and someone explained, like, they're under hypnosis. Let me tell you, I would love to be hypnotized. Because I don't believe in hypnotizing. I think it's a bunch of crap. So I would love to be hypnotized. Find out if I was a serial killer in my last life. But it's like they keep talking about reincarnation and stuff, and I don't know. I don't know if I believe in reincarnation. I don't think I do. But the way they talked about this soul, it's exactly how I had this dream the other day. So, I mean, yeah, the other day. So it was just kind of weird. But that's a whole nother topic and a whole nother conversation. So, all right. Yeah, they say people soul jump. But, again, that's a whole nother conversation. A whole different life. Why am I killing you? Are you famous with Brittany Murphy? Huh? Who's Brittany Murphy? Bridget Murphy? No. Hypnotize Lauren tells she's an honorary opponent. I'm telling you, I would love to be hypnotized. No one really knows it. That's what I'm saying. Because they don't remember their past lives. Well, according in the soul life, you do. According to what people are saying in the soul life, you absolutely do. That once you die, you go into a soul life. You go back to this place where you see everyone. And then you transfer to another life. I don't know if I believe that part. But like I said, this one dream I had about Brad the other night coincided with this one story. It was weird. Yeah, Brittany Murphy. Thank you. I couldn't remember her name. Oh, speaking of, Whistle Down, should I show that thing? Or should I save it? Have you guys seen Whistle Down's videos on Summer Wells? If you have not, please go check them out. I will play them tomorrow on a live, if you haven't checked them out. Yeah, your human life doesn't remember, but your soul does. But Whistle Down, check out her channel. She's got some great videos on Summer Wells. Okay, I want to show everyone this because there seems to be, from Krama Mama to Chasing Truth to a lot of people, I want to show everybody how simple this is. And I'm dumbfounded that people don't know this. Because it's really, really simple. Hold on. Let me clear my whole screen. Okay. Whoop. So if you want to turn off Super Chat, you go to your YouTube studio. You slide on the right to monetization. This is where I could show my screen from. On the left, you hit monetization, okay? And then you go to supers. And look what you see. Super chat, super stickers, super thanks. If you want to turn it off, you just click the button. That's simple. And that's it. That's all you have to do. It's that simple. So all these people who say that I can't turn off Super Chat, yes, you can. It's very, very easy. So, yeah. So I just wanted to show that. And it probably will be featured in Whistle Down's video. But yes, very simple to turn off Super Chat. Or super stickers or super thanks. Which again, super thanks I just got. Woo woo. And super thanks means that you could super chat me while I am not online. So if you watch a replay and you want to super chat me, you can. That's what super thanks is. But yeah, I just want to show that's how simple it is. Easy breezy. There's no big thing to it. Yes, it's very simple to turn off super chats and then you turn it right back on. Hey, Coffee. It's a toggle button. That's it. So, anyone that says otherwise is lying. I think Ziggy said you can't turn off super chat. I think a lot of them did. Yeah, you can. You can turn off all of it. So, just want to put that out there. And if they didn't know that you could do it, now you know. Now you know how it's done. Some are being exposed. Oh, are they? I'm just saying that it's that simple. And if maybe they didn't know, well, now they know. It's that easy to turn it off. And I said it that day. I was like, it's so fucking easy to turn off Super Chat. What are they talking about? Guess YouTube got tired of not getting money when creators weren't live. Took them long enough to have the super. I know. No, some people got the super thanks immediately. I've been waiting like a year. I'm like Save Robbie got it way back when. I'm like, why don't I have it? I'm a super chat my fat ass to bed. Thanks, Brian. I keep eating like I did today, and I'm like, I'm going to be fat again. 10 minutes behind? You're welcome, Whistledown. But yeah, check out Whistledown's videos. If not, I'm going to play them tomorrow. I love her videos. She makes awesome videos. And she's got an awesome husband who agrees with me. So there's that. Alright, I'm out there. I really I got people coming to pick up candles tomorrow. So I will see you guys later. Have a wonderful day. Have a wonderful night. And I told my friend, I said, you can't light them though. I'll have them done for tomorrow, but you can't light them. So she's like, okay, I won't light them for a few days. I said, you gotta wait like a week. I said, but I will make them tonight. So even though it's nice and cool. So I'm going to listen to my book. And I will see you guys tomorrow. Thank you guys for Super Chat, PayPal, and everything else. I'll see you guys later. Have a wonderful night. Peace out. Peace, love, shrooms. And have a good day. And I'll wait for your list, Lindsay. Love you.